I'm Sean Wilentz. Welcome to the Court of History with my compadre, partner in something, in many things, especially the court things legal and historical, Sidney Blumenthal. We're going to go back to talk about the Supreme Court, directly about the Supreme Court. Those who've been following us know that we've talked about the court a fair amount. We've been talking about things that are about constitutional, legal, and historical matters, but now we're going to get back onto the court itself. And Sidney, I was thinking I'm thinking more than I wanted to about John Roberts lately. And, you'll remember some time back when the president was saying that he was going to impeach a lot of judges, right? That this was, he's going to impeach this judge and that judge. They're all a bunch of crooks and phonies, et cetera, et cetera. And then John Roberts objected, and he got a lot of credit for having objected, having stood up to the president of the United States, right? And defending the Supreme Court from this, would-be authoritarian. And I wrote down the quotation of what he actually said at that time, which was the following, quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial, decree. The normal appellate review process exists for that purpose." Right? So that was John Roberts dressing down the president. But, looking back on that doesn't look like a dressing down. That looks like a bit of advice to the president, which is to say, don't go to impeachment. Just come on through the normal appellate division. You'll be okay. What do you think?
They've been the Supreme Court has been knocking down appellate decisions one after another on the shadow docket without offering any actual decisions. There have been rulings, but no opinions.
Right.
There's no reasoning offered. It's utterly arbitrary, in keeping with the autocratic logic of what they're upholding that Trump is doing, case after case. And the question is whether or not John Roberts is engaged in a feckless appeasement strategy or not, and hopes that somehow he can fend off Trump and in the end then retain the independence of the court, whatever that means, to do whatever purpose it might be. There's a lot to talk about here.
There sure is. And we have just the person to talk about it with. We're very, very fortunate to have with us today Leah Litman. Leah Litman is the professor of law at the University of Michigan Law School. She's also the co-host of Strict Scrutiny, a podcast about the Supreme Court of the United States. She's the author of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes, about which the New York Times Book Review has said that Lawless renders dense constitutional analysis into something urgent and accessible, nothing less than a field guide for navigating our current constitutional crisis. Welcome, Leah. Welcome to the Court of History. It's great to have you here.
Thanks so much for having me.
The court's in session.
I'd rather be in the Court of History than the Supreme Court. So happy to be here.
Indeed.
But you are in the Court of History to talk about the Supreme Court.
Well, yes. And as Sidney is wont to say, this is, of course, the highest court. It's the Court of History. So, we can do it that way.
Certainly by ethical standards and principles.
Well, in the end, assuming there still is history, but that's another whole topic. Leah, people come up to me all the time, I suppose you too, and want to know what's with this court, right? And some people say, is it just a MAGA court that we didn't really realize it until the immunity decision or something, that's gone full MAGA with the exception of the 3 liberals, obviously, but enough of a majority? Or is it, as Sid was just suggesting, is it just John Roberts trying to, preserve in some misbegotten way, try to preserve the court's power or its relevance, its authority, by trying to appease the president? What do you think? Do you have any thoughts about that?
I think it's a both and situation. I think there are certainly some members of the Republican supermajority who I would describe as MAGA and basically on board with a lot of elements of what the Trump administration is doing. I think of John Roberts as someone who does care about the perception of the Supreme Court's institutional neutrality, even if he is unwilling to make substantive rulings that would actually shore up the court's institutional legitimacy. I also think that even those Republican appointees who are probably put off by some of what Donald Trump does are in reality also on board with a lot of what the Trump administration is doing, from, for example, expansive assertions of executive authority, firing the heads of different agencies who are supposed to be independent of the president. Those are things that they think they can basically get, in some sort of deal with Donald Trump.
Yes. As you've seen in your book, I mean, Neil Gorsuch is on record, even before he was, appointed, saying that basically the administrative state is a monstrosity, which is very difficult to square with the Constitution of the United States. Kind of announcing beforehand, this is what he's going to be doing, and now he's doing it. I mean, that was about as MAGA as you can get, right?
Exactly. I mean, like you had Steve Bannon declaring during Trump 1.0 that their goal was deconstruction of the administrative state. What is the jurisprudence of the Republican appointees on the Supreme Court, but to defang administrative agencies, seize more power for the courts and for the president at the expense of those independent agencies.
Right. And as Justice Kagan once said, the administrative state, what does that mean? That means basically the government we've got, and that's what they're really out to wreck. Well, do we want to say who the break it down? All 9 of them? We know about the 3. I want to talk about the 3 liberals actually a little bit later on, because they're showing some interesting differences among themselves of late. But is it just is it Alito and Thomas, and then where do we go? Is Gorsuch seems to be full MAGA, and then there's the internal mystery of Justice Barrett. Is it 3 and 2 and 3? Is that the way it's working?
Honestly, I still view them as a core 6, with Thomas and Alito just kind of anchoring the wingnut aspect of that coalition. Yeah. And I say that they are 6 because all of them have some issue or maybe issues in which their views are slightly more idiosyncratic or heterodox compared to their Republican colleagues. For Neil Gorsuch, it's federal Indian law. For the Chief Justice and Brett Kavanaugh, it's this small subset of criminal procedure issues where they look at a case and just think, this cannot be. For Amy Barrett, it turns out that's been 1 or 2 issues of executive power. Like, for example, whether a state court can sentence Donald Trump, to the 34 felony convictions on which he was convicted. And so I don't really view the Republican coalition as having any great real mystery underlying it, including Justice Barrett. I'm happy to talk more about that. But I think all of them have their issue in which they're a little bit different. And it just so happens that Justice Barrett's issue is the one that has been most salient over the last year.
Right.
Yeah, I wonder, what their mentality is at the present moment, because the mentality of the Republicans in the Congress is that this is their moment when they have absolute power over both chambers and the presidency, and they have a majority in the court to do everything as quickly as they can, with the possibility that they may lose one or the other chamber in 2026. Supreme Court, of course, has a lifetime tenure, and that gives it a different sensibility. But how plugged in are they to really going the limit here with Trump to get their maximum program, that their wish list?
I have called them the YOLO court, the you only live once court, for a reason. You're right, they have lifetime tenure, and so they can wait things out in a way that elected representatives cannot. On the other hand, they have been ticking off the wish list of the right-wing legal movement with considerable pace. They overruled Roe versus Wade. They ended effectively affirmative action programs in higher education. They overruled the Chevron doctrine, under which courts were supposed to give deference to administrative agencies. they just upheld a law banning gender-affirming care for transgender minors. If you look at their docket, they have cases about the end of the future of the Voting Rights Act. They have cases about whether discrimination against transgender individuals is unconstitutional. So I think they are really moving at a quick pace in order to do a lot of what the Republican legal movement has been wanting to do for a while. And I think Donald Trump gives them an occasion to do so in at least two different ways. One is Trump just siphons off so much attention from what the court is doing that they don't get in the same amount of trouble that I think they would if they were occupying more of the public's focus and attention or more front page news. I mean, my goodness, they basically gave states the power to defund Planned Parenthood at the end of the term. And that decision was completely drowned out by whatever the latest insanity was out of the Trump administration. And then Donald Trump also gives them the occasion to expand presidential power, which has also been a big part of the conservative legal movement. And given how he is wont to basically claim the power to do everything, that gives them many different cases to affirm their increasingly expansive vision of presidential power.
Yeah, and they're doing it without having to justify it, right? And this is where the shadow dockets come in. I mean, it's all being done. They're hiding, but it's really extraordinary. I've never seen anything like this in American history.
Yeah, so I think it is really symptomatic of how they are just not behaving like a court. They are behaving like an arm of a partisan agenda where they're basically just giving the executive branch permission to implement its policies without bothering to provide reasons for why the executive can do so consistent with the law. In my view, they have enabled the Trump administration to get off scot-free with violating several lower court orders. And I think that too is another way in which they are just not behaving like a judicial institution because they don't seem to care that the administration is pretty openly defying lower court orders.
Yeah, Roberts isn't saying nothing about this. While he made an anodyne comment earlier about the extensive violent threats to judges across the board. And yet he's trying to maintain his image as an institutionalist, which at this point strikes me as an empty image. And he increasingly is removing the mask of partisanship from the court. In particular, Roberts' main issue of concern to him over the years, over decades, has been the destruction of all the legislation involving the civil rights movement, and particularly voting rights. And that's his special mission. And yet he cultivates the institutionalist perception.
I think he is a superb politician in being able to make decisions and cultivate an image in the media, which is way more favorable and generous than he deserves. You're right, of course, that when he was a young lawyer in the Reagan administration, he was authoring memos describing how violations of the Voting Rights Act shouldn't be too easy to approve and opposing the expansion of the Voting Rights Act. Also as a lawyer in the Reagan administration, he was writing memos urging that presidents should be able to have more power over independent agencies and that independent agencies were unconstitutional. Well, guess what he has done once he was a justice? Dismantle a key provision of the Voting Rights Act. They have another provision, really what remains of the Voting Rights Act, potentially in their crosshairs for next term. They have all but destroyed independent agencies just over the last year, in addition to the decisions that have been undercutting them for the several years prior. And so I think his behavior on the court just doesn't look that different from his behavior as a political appointee, an executive branch lawyer for a Republican administration. And I think it's very important for people to understand that these justices, they had careers, before they were appointed to the bench, and all the things they said, did, believe, they don't disappear once they become a justice.
Yeah. Just to finish up on on Roberts in particular. We had Judge Ludwig on the show a few episodes back, and he's a good friend of the Chief Justice's. He talked about it, and we asked him, what's in his mind? Does he realize that people are ranking him, right there with Roger Taney as maybe the worst, Chief Justice of the United States? Is he aware of that? Is he? And it's interesting. The judge said yes. Yes, he hears all of that. He's self-comprehension is not his weak suit; it's his strong suit. He understands all of that, and yet he's going along with all of this stuff anyway. Is that a puzzle?
So I don't really view it as a puzzle. I think it is more of a reflection of our increasingly polarized politics and media, the democratic decline of our institutions, and also this conservative grievance mindset that has overtaken the Republican Party. So the increase in polarization means I think the Republican appointees are increasingly comfortable just focusing on the views of Republican commentators who are part of MAGA and the Republican media who is saying great things about the things that they are doing. And they feel more comfortable discounting independent media, bipartisan voices, progressive voices, and whatnot. I think he also has less reason to care about general public opinion, given how hard it is now for popular majorities to win the presidency and to win control of Congress. And so when he faces less prospect of political pushback from simple majorities, that too gives him an excuse to just care less about what general public opinion is. And then you add to that this idea that has just cannibalized the Republican Party, which is that everyone is out to get Republicans and Republicans are somehow the big victims. And I think that too might play into a mindset that allows him to discount fair, reasonable criticism of what the court is doing.
Yeah, I want to talk to you about that ideology of grievance, which they have translated into a rhetoric and then translated it again into a jurisprudence. I have spent a lot of time with Abraham Lincoln, and the Confederates and the Southerners before the Civil War, also developed this ideology of false grievance. And some of the same rhetoric still endures today that existed then as the rationalization of slavery, and in particular the word liberty. Because liberty was used by the slave owners in terms of their liberty to own human property. And Lincoln fixed on this and delivered whole speeches deconstructing their manipulation and exploitation of this rhetoric. And yet this same word now has come back to justify the imposition of Christian nationalism and to destroy the separation of church and state, just as an example of the kind of ideology of grievance that's entered into the destruction, really, of American law.
I'm glad you started. Sorry, go ahead.
Jumping very quickly, there's a perfect quotation from a Southern newspaper on the edge of secession, which ran a quote. I'm quoting: "Freedom is slavery."
Yeah, so I'm glad you started out with the example of the former Confederacy, because I think that is one of the more astonishing, instances of turning oppressors into victims. And actually, the first paper I wrote as an academic, which was my job market paper, was about how the Supreme Court's decision in Shelby County versus Holder, which had dismantled a key provision of the Voting Rights Act, actually channeled parts of the Lost Cause and Redemption movement, which argued,
of course,
exactly, that's a Roberts opinion. And so, that movement, of course, argued that the North was basically too mean to the South, and that it was imperative, here I might be paraphrasing or quoting one of the examples from my book, but imperative to treat and respect the South as an equal. They turned the Confederacy into the victim of Reconstruction and used that idea to dismantle Reconstruction and usher in Jim Crow segregation. And you can see those same ideas in Shelby County versus Holder, the Roberts opinion that dismantled part of the Voting Rights Act. That opinion talks about how the Voting Rights Act is disparate treatment, a legal term of art for intentional discrimination against the former Confederacy. So in this case about the Voting Rights Act, the crown jewel of the civil rights movement, this protection against voter discrimination. In a case about voter discrimination, they turn the former Confederacy into the victims of discrimination. And it's that sort of inversion of discrimination and equality that I think anchors a lot of different areas of law. And all of the chapters in my book are about different areas of law that reflect that idea. You mentioned this idea of Christian nationalism, discrimination against religion. Happy to elaborate more on how that area of law has just been completely cannibalized by this idea of conservative grievance.
Yeah, I don't want to leave this for a moment, but let's just fix the point on John Roberts here on Shelby and its root in Confederate thinking, from which has, the fruit of this poison tree is the destruction of the civil rights legislation and the Voting Rights Act. And it goes all the way back. So that the comparison of Roberts to Roger Taney, who was the author of the Dred Scott decision and was Chief Justice then, from Chief Justice to Chief Justice, is not sheer polemic, but in fact, a kind of direct lineage.
Yes. I think that the Roberts Court has a series of what I would describe as neo-Confederate rulings in which they are ushering in, the pre-civil rights movement world in which we lived in, from hobbling, the pre-clearance process of the Voting Rights Act to undermining what remains of the Voting Rights Act's protections against discrimination, to ending efforts to integrate, institutions of higher education, to undermining Section 1983, the general federal civil rights statute that was a key part of Reconstruction. This last term, in their decision about whether you can challenge a state's ability to exclude Medicaid providers, the statute that they weakened was Section 1983 in that case. So I think there are many different rulings that reflect that sort of neo-Confederate ideology and neo-Confederate results. And it's no accident that in that case, Justice Ketanji Brown Jackson's dissent likened the Supreme Court's decision in that case to previous efforts to undermine civil rights protections in the wake of the Civil War, and likened the court what they were doing recently to the court facilitating the end of Reconstruction.
Well, Leah, you actually hit on just what I wanted to talk about next, which is Justice Jackson and the differences among the liberals and how you deal with. I love the idea. I don't like the idea of calling this court the Neo-Confederate Court rather than just simply the MAGA Court. I think it's a very, very important point. But what do you make of that distinction, of that split, if you will, or if it is a split? There's certainly a different way of dealing with it. What do you think?
It is very, I think, notable to me that there are real differences between the Democratic appointees in their willingness to write separately, the tone and register in which they write separately, and to call out their colleagues, for engaging in behavior that is not consistent, with, I think, judicial standards. I think Justice Jackson has shown herself to be very willing to speak in ways that are easily understood and translatable to a broader audience than maybe could read a typical legal dissent. I think she has also been willing to say things that some of her colleagues have not, even though some of Justice Kagan's dissents have been quite pointed. She referred to, for example, one of the court's previous decisions that's not just inadequately explained, but also poorly explained, and she has had some, sharp words. She accused a Justice Alito majority opinion that undermined the Voting Rights Act as occupying a law-free zone. So, they have had their sharp words, but I do think Justice Jackson's willingness to identify broader patterns in the court's jurisprudence and fault the court for that, and the plainness with which she speaks is really different. As to what explains it, I think part of it is a temperament issue. I think part of it is that Justice Jackson came to the court after the end of Roe versus Wade. And so she was not engaged in this project of trying to compromise and appease the justices to ward off, the end of Roe and potentially other rights as well.
Yeah, let me just say on this point, do you think that Justices Kagan and Sotomayor actually think that somehow that by tempering their rhetoric in their dissents, that unlike Jackson, that they can persuade their colleagues to a more temperate position and lead to further compromises. And do you feel that this is a kind of delusional politics or a practical politics, and that Jackson is engaged simply in a rhetorical project rather than an actual politics?
Yeah, so I do think that both Justices Kagan and Sotomayor, Sotomayor probably to a lesser extent, think that, declining to dissent, declining to write plainly, sometimes joining, with the Republican appointees to cobble together majorities, that those are all ways in which they might be reducing the speed, with which the court arrives at, its radical refashioning of law and society. What do I think about that? I do think that they are probably able to get some things in the short term that might forestall or at least delay the inevitable. Is that worth, the trimming their sails and appeasement? On that, I probably find myself more in agreement with Justice Jackson that at this point, given everything the court is doing, the court's just inability to care about law, to provide reasons, and the extent to which they are enabling the Trump administration, that all of that combined means it is more important to call out the court and try to, energize the public, the Democratic elite, to understand the extent to which the Supreme Court is now part of our democracy problem rather than a solution to it.
When you said something about the inevitable and also about them getting something. What is the something they think they can get, and what's the inevitable?
Yeah, so let's think about the court's steady destruction of the Establishment Clause. Over the last, let's say, 10 years, the Republican-controlled Supreme Court has increasingly invalidated measures that sought to limit the extent to which states were supporting religious schools, right? They sought to limit the extent to which states could decline to provide funds to religious public schools. At first they said, okay, well, states have to give them money for non-religious reasons like playground resurfacing. And then it became, oh, well, actually, you have to give money to schools generally as part of tax exemptions. Now, all of a sudden, we are on the precipice of them saying states are obligated to create religious public charter schools. The inevitable is like the complete demolition of the separation of church and state and the creation of prayer in schools and religious public schools. So I think that the Democratic appointees, right, kind of delayed that, by joining rulings that said, oh, we're just saying states have to give money to playground resurfacing rather than saying 7 years ago, states have to fund religious public schools. So that's kind of what I mean by delay and forestalling inevitable.
Mm-hmm.
And how much of it might be, you mentioned Dobbs earlier, Leah, and that's true. But Jackson's also the first, what should we say, post-Trump appointee. Post-Dobbs, but she understands, I think, the way, what's going on really in a different way than either Sotomayor or Kagan would. That they came out of a time when there was a normal court. Let's say it was a conservative court, but it was a normal court. Yeah. Degrees of normality. But in any case, it's not the way it was then. And that she sees that in a way that's, with greater clarity, perhaps, than it's not just a matter of temperament, it's a matter of experience.
I think that is also probably part of it. I look at law students today. I look at my time as a law student, and I look at, the people who taught me law. And I think we all grew up and were socialized in and, began the profession at very different moments for the Supreme Court, the federal courts, and the legal profession, more broadly. I clerked at the Supreme Court when the court came within one vote of dismantling the entire Affordable Care Act based on this cockamamie theory that was completely inconsistent with precedent. So I saw up close, a court that, in my view, was on a steady decline and on the precipice of just imploding and no longer functioning as a court. I think law students today see a Supreme Court that is enabling, a president who behaves in autocratic ways. And so, yes, I think that sort of professional development and experience absolutely colors one's assessment of institutions and the right approach to take within and to institutions.
Yeah. This raises the question. You're a law professor teaching constitutional law, and yet the Constitution's literally being dismantled before our eyes. In the past, the ideology that was offered as the rationalization for all of the decisions to achieve conservative ends was originalism or history and tradition or textualism, and now they've gone beyond it to nothingism, offering no reasoning, but also into a kind of authoritarian post-constitutionalism that's beyond any even originalist conception. And what's your view?
Yeah, so part of what I try to describe in the book is how the justices basically used tools like originalism, as cover to enable the Republicans' agenda. But that's what they were at the end of the day. Tools. They were pretty convenient, at confirmation hearings, because that allowed appointees to say things like originalism and textualism rather than women dying in parking lots. And now, that they have a supermajority and again, more insulation from popular majorities, I think they are emboldened. And so, I think the court is increasingly acting like everything, or at least most things that Donald Trump does, are just the law, and they treat his edicts as the law because those represent, the policies and views and preferences of the Republican Party. They don't bother to explain themselves. When they do explain themselves, there isn't a lick of history or focus on the text of a statute. In opinions that explain, what the free exercise clause or establishment clause mean, it's not like the justices are doing some extensive analysis of history, in their opinion, announcing that the president enjoys immunity from criminal prosecution. I mean, that would just be horrifying, to the people who drafted and ratified the Constitution, who sought to make a system where there are no kings. And I think the reasoning in that decision just reflects the justices' pragmatic assessment of what is worse, criminal liability for the president or, a president who is unfettered and unbound by law.
Yeah, I mean, Trump v. U.S., to me, that was the signal that they'd gone beyond originalism, that now it's going to be just raw power. And really, that's what the decision says. He says that, the president should have a lot of power, so we're going to let him have a lot of power. That's the reasoning. There's nothing
right.
more than that.
It would be good for our constitutional system if presidents, had the ability to act without being fearful of, criminal consequences.
They know better than Madison. They know better than everybody. It's all there. Right.
I thought one of the telltale signs recently was the confirmation hearing for Emile Beauvais to the appellate court of the third district, and as an afterthought, Josh Hawley, senator from Missouri, said, "You're an originalist, right?"
Just check the box, please.
And he actually said it. He said, "I believe in a textual reading
you're
of
textualist." And then he asked him about textualism, and do you forswear Satan and all of his works? And he, basically Beauvais said, "Yeah, boss, whatever you say."
Yeah, but it has become a code word, a sort of euphemistic code word outside of the court, outside of the judicial system. It's now everywhere. That if you want to, kill women, just say you're a textualist. That's fine, but it's everywhere.
Yeah, and so part of what my book does it describes the rise of originalism and how when originalism was first being floated, by the Reagan administration and the Federalist Society, they needed to basically signal what they were saying when they said originalism. And so you had officials in the Reagan administration saying quite explicitly, a jurisprudence of original intentions is the way to roll back things the Warren Court did, like recognizing rights for women, minorities, and criminal defendants. And then you had Reagan administration administration officials writing, in books, documents for the executive branch, that originalism was a way to advance the social issues and social policies of the Republican Party. And once those views become fused, once they become so associated with one another, you don't need to say that anymore.
Yeah, and a major element in making this all possible, of course, was the Federalist Society.
Yes.
And Leonard Leo and his group. And recently there was this spat between Trump and Leonard Leo. Didn't he call Leonard Leo an evil person for a while? But he seems to have these spats and they disappear.
He's still appointing Federalists.
Exactly.
People, from Leo's list.
Yeah, he's just looking for the most hackish among them.
Right.
Yeah. I want to ask you about another thing. What Theda Skocpol of Harvard has called McConnellism. And that also gets us back to the Gilded Age court, the destroyed Reconstruction,
right?
But also this particular strand of McConnellism is devoted to destroying all barriers to the influence of big money. And John Roberts has been instrumental in this, beginning with the Citizens United decision. So this has laid the groundwork for a new Gilded Age, and this is a new Gilded Age court as well.
I totally agree. This is another one of the areas of law, not just campaign finance, but also the law of political corruption that I write about in the book, because I think the through line in the campaign finance decisions and the decisions on political corruption is this sense that the super rich are just entitled to buy influence and access, to spend unlimited amounts of money. And that's just the way for them politics works and should work. And here too, you have this wild grievance narrative where in the campaign finance decisions, the court is obliquely talking about how the First Amendment protects, the rights of minorities. Well, which minority is the court protecting? The rights of the mega rich, who the court thinks campaign finance legislation unfairly discriminates against, by not allowing them to basically use their accumulated wealth to purchase political power. The reasoning in these decisions is just ridiculous. In Citizens United, for example, the decision you mentioned, the court says things like, well, these unlimited corporate expenditures, they're not going to give rise to corruption or even the appearance of corruption. I'm sorry, the 2024 election basically gave a lie to that. We all saw the richest man in the world purchase himself a seat at the table, with access to the White House. So yes, these decisions are very much part of the new political order that I think the court is constructing and deeply committed to.
Yeah.
It's the money talks rule,
Yeah. So we also have an unprecedented attorney general to match this kind of Supreme Court, Pam Bondi, who exists to implement the whims of Donald Trump. And I wonder what your view is in relationship to what she's doing and the court.
I mean, I think she has just so thoroughly discredited herself, in any number of decisions. She was one of the people who was repeatedly insisting Kilmar Abrego Garcia, the man who was wrongfully expelled to El Salvador, would one, never return to the United States, and two, was some sort of violent gang member, something they have been unable to convince, any judge, to date. So I think, yes, you're absolutely right. This is another kind of crony loyalist who has been appointed to the Trump administration and who is just content, kind of parroting the lies and, dishonest talking points, that dear leader provides her.
Yeah.
But now she's caught up. I mean, the Epstein business. I mean, now she seems to be, whoops.
Yeah. What's your view of the legal issues involved in the Epstein issue? We now have the dangling of a pardon or clemency to Ghislaine Maxwell by the Deputy Attorney General acting on behalf of the president.
The president's private lawyer.
In exchange for clearing him, perhaps, or incriminating his enemies within. We don't know. And Senator Dick Durbin today sent a letter to the Justice Department demanding to know exactly what Todd Blanche, Deputy Attorney General, asked
former personal attorney, or maybe not former personal attorney to Donald Trump.
Right. Asked
same job now.
Maxwell and what her responses were. She has filed now her latest appeal to the Supreme Court. It's not a new thing. It's reported as though it's new. It's not new. She's been doing this all along. They've been kicking the can on it, and and they've been opposed. The administration has opposed any request on her part to throw out her case, and said that the matter's closed and she deserves her sentence until now.
Right.
So, I mean, where does this Epstein thing go, and can it ever get? I can't imagine, but one never knows the perversity of what goes on, of how it gets to the Supreme Court.
Yeah, I mean, legal issues, where does it go? I mean, to my mind, this possible exercise of the pardon power is just part of a broader project and pattern of Donald Trump abusing and using the powers of the office to advance his own personal interest and political gain. Like, to him, there is no conceptual space between a public purpose and benefiting Donald Trump and his political interests. And so he just uses, right, like all powers of the presidency to that end. And I think dangling this pardon, for Ghislaine Maxwell to basically potentially incriminate, his political opponents and exonerate him is very much a part of that pattern. As to the law, I mean, pardon power is one of the powers that the Supreme Court, in their egregious immunity decision, listed as exclusive to the president. And basically, you can't challenge it, even if it is exercised for impermissible purposes, right? For personal retribution or private gain. So I agree. I don't see there being a way to really challenge a possible pardon for Maxwell in the courts. And that is, again, this deeply awful consequence of allowing this autocrat, who is one of the worst people in the world, to hold the office of the presidency.
Yeah. So there's also the question of the suppression of the actual Epstein files as opposed to the fictional ones,
right?
And the resistance to releasing them, and what they might do to, redact them. So what's your view?
I mean, they could tomorrow, if they wanted, release all of the information in the government's possession about Jeffrey Epstein, his supposed client lists, right, or any sort of blackmail, he engaged in vis-a-vis the powerful individuals who were part of his network. The fact that they haven't done so is a choice, and my guess is it probably reflects their assessment of the political interests of Donald Trump and the Republican Party. I think the fact that this administration is so willing to brazenly lie over and over should give us real hesitation and pause in the event they release anything, whether it's redacted or whether it's not, as to whether the information that they are providing us is remotely complete. I also think they are attempting to create this sideshow and distraction to get away with not releasing the Epstein files by going to court and asking courts for permission to release the grand jury files, which again, they can't do without court's permission. And in their legal filings, they're not even trying to convince courts they have satisfied the requirements for the release of grand jury materials. I think they are just setting up a fall guy, the courts, for them not releasing any more information related to Epstein.
Yes, Leah, you used the word brazenness, and that's what it really becomes. I mean, it's with the Maxwell business in particular. I mean, it's so transparent what's going on. Yeah. I mean, we were talking about this being a cover-up, but usually when you have a cover-up, you're trying to hide the fact that it's a cover-up. They're blaring with a megaphone in Times Square that it's a cover-up. I mean, it's extraordinary how far they're willing to go.
It is one of those things where the cover-up, right, is probably not worse than the underlying crime, but they are certainly conducting it in a way that makes it all the more of a focal point.
Okay, we're just about out of time, unfortunately, but Sid, you want to ask one last question?
Well, where does the court go right now? Some people hold out the hope that there's a Hollywood ending here. There's a happy ending, that they're engaged in all this appeasement of Trump in order to buy what will be, resistance to Trump in the end. And this strikes me as human nature hoping for an optimistic conclusion in the face of harsh reality. What do you think?
Yeah, what you just described as fiction, I wrote a nonfiction book. The reality is the court is going to continue advancing, the Christian nationalist elements of the Republican coalition and the Trump administration, targeting trans people, attacking civil rights for minorities. At the same time, they are going to continue granting Donald Trump, an ever expanding set of powers to violate laws, that insulate individuals from presidential firing. They are going to continue to give him relief from lower court orders that rule against the administration, suggesting the real problem here is not Donald Trump's many legal violations, but the fact that lower courts would deign to do anything about it. I am not holding out hope that the court is going to save us. I think it is clear they are not, even if, in some case here and there, they might rule against the Trump administration.
Well, with that dose of reality that we all very much need, if we're going to get anywhere, we have to better understand where we are. And you've certainly, Leah, really shown us a great deal about where we are, for better and for worse. At any rate, thank you so much for coming on. It was great. You've been a great guest. Having you is a real pleasure. And for Sidney Blumenthal and myself, Sean Wilentz, and the Court of History, we'll see you next time.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.